Is your will the only way to transfer assets to your loved ones after you die? My name is Andrew Ayers. I'm an estate planning and business law attorney, and today we're going to talk about the different ways in which your assets can be transferred after you die. Now, there's going to be four main ways in which this can be done. The first is with a will. The second is through beneficiary designations. The third is through legal title on the asset. And finally, the fourth one's going to be under local laws. So the most common way people think about transferring assets after their death is by using a will, which is going to be the primary document in your estate plan. And that will say after you're gone how you want your assets to be divided up. If you have specific things that you want given to specific family members, your will specify that. If you have to designate somebody to take care of your children, your will have a provision for guardians. And to manage their money, it'll have a provision for trustees. But beyond a will, there's actually three other ways that your assets can be transferred after you die. The second way that assets can be transferred, and a very powerful tool in your estate planning box, is through beneficiary designations. Many people don't understand beneficiary designations as a part of their estate plan. For example, you start a new job, you set up your 401k, you're filling out all your paperwork, and one of them says who should be the beneficiary on your 401k. Some people think about it and make sure to put down a spouse or put down certain family members in a certain order, but unfortunately many people leave it blank or just say, oh, give it to my estate. The problem is, by leaving it blank or giving it to your estate, all of that money you've earned in your 401k now has to be transferred to your estate, and depending on how much money you've earned, you may have created an estate tax problem. However, if you've done a beneficiary designation, for example, a designation to your spouse, then what happens is, regardless of if you have a will or not, that money is transferred directly to your spouse upon your death. And if they have retirement accounts to which it can be rolled over, there's even tax benefits to doing it that way. Beneficiary designations are found across a variety of different bank accounts and financial institutions and other financial tools. For example, life insurance, also a very important designation of a beneficiary. If you don't designate a beneficiary and you have a large life insurance policy, let's say a $10 million life insurance policy with no beneficiary, you've now almost certainly created a tax problem for your estate. The third way that you can transfer assets after you're gone is through legal title. And what I mean by this is things like transfer on death deeds. So depending where you live, your local state may allow for you to have a deed for your house that says when you die, the house automatically goes to somebody else. This is essentially a beneficiary designation that we can use for real estate. Now, caution here, not every state allows for transfer on death deeds, but they may allow for other mechanisms like using wills and trusts or an LLC to put your property in to get around the estate tax problem that you may have. And then the fourth way, and the way that most people don't want to go, is through your local laws. And when I say local laws, that means you've died without a will, you don't have an estate plan, there's nothing really left over for anyone to figure out what you want to do, so now your family has to go to court. They have to file proceedings, file your death certificate, your will if you have one. But if you don't have one, what happens is the local laws control. And that brother that you haven't spoken to for 20 years, he may be the only one in the stage chart who gets to inherit, and now all of your assets are going to him instead of somebody else who you would have preferred. So these are the four main ways that you can transfer assets after your death. Now there's two main ways you can approach this. The first way is try it yourself. You can try to create transfer on death deeds, you can make sure your beneficiary designations are up to date, which you should be doing anyway, or you can try to create a will or an estate plan. But the second way, and the way you're going to do it because you've taken the time to research this topic, is you're going to work with professionals, work with your financial advisor, your accountant, work with an attorney to create a comprehensive estate plan. We don't want to fall in that fourth category of the local laws just dividing up your assets. Let's use the first three: your will, beneficiary designations, and transfer on death designations if possible, to make sure that your estate plan protects your legacy and your assets go to the people you truly love.